I'd like to thank both Neil and Glenn for inviting me here today. Appreciate it. But I'll get started. For those who don't know me, I'm a QS by background, and I've since qualified part-time as a lawyer over many, many years, about 15 to be exact. Yes, contractors QS by background. Today's talk is going to be about disallowed costs, a topic I've dealt with as a QS as well as a lawyer. I've been involved in quite a few NEC projects over many years. So anyway, we'll get started. There's a section I've taken out of here. So you see on the agenda, it mentions defined costs, but in terms of the timescales, that's something which I've taken out. So you notice that's missing, albeit it's still on the agenda here. So yeah, item number 3, we won't be dealing with, but ordinarily, if we had more time, something that we could have dealt with. But so today, what I intend to do, we've got a brief introduction, and specifically just take the disallowed costs provisions, and I'm going to just talk through each of those provisions and my understanding of it. And you may tell me I've got it wrong completely, but we'll see. And then there's one case which, there's a few cases I wanted to discuss, but I think in the timescales, there was only one which I've picked up that I'm actually going to go into some detail, some brief detail on, and then conclude. So disallowed costs represent, I'd probably say, the most important risk to contractors and contracting organisations in respect of the options which I've identified, options C, D and E. Now, what's the purpose of having disallowed costs? There's quite a lot of reasons, but certainly I've mentioned 2 of them which I think are very relevant, to encourage the contractor to claim defined costs, but more importantly, in accordance with the actual contract which you've signed up to. Also to prevent recovery of undefined costs during the administration of the contract, which is administered by the PM. So what is disallowed costs? Now, what I've done is to take each of the provisions out of the contract, and then I've given a brief narrative as such to each of them, which we can pick up in discussions later on if everyone's got different views, I'm sure, which is a topic that we could debate for many hours. But in terms of disallowed costs, it's costs which are not justified by the contractor's accounts and records. Now, what do we mean by that? Contractors' records don't sufficiently demonstrate that the cost incurred has been in providing the actual works. So this could be invoices, waiting time, and more importantly, how is that actually evidenced? For example, with dates, reasons, etc. So we've got timesheets, etc., saying waiting time. What were the reasons? Poorly drafted timesheets, etc., where you don't actually cover in full the reasons and exactly why, etc., for it to be classed as defined costs. So what level of detail is required within those records in terms of events that have occurred to ensure that those costs are not disallowed? Coming back to it, in terms of substantiation, what exactly are we looking at in terms of payment? Now, I've put the word internal records there, CVRs. Now, I would argue that that's not something that's relevant. That's something that's internal, and it's got absolutely nothing to do with the PM. But I've had instances where the PM's actually said, look, we'd like to have a look at your internal recording system, such as CVRs, but I don't think that's not something that I would expect a contractor to divulge, and it's purely, for me, it's for internal purposes only. So it's important to be just mindful in terms of what level of substantiation you're being asked for. Timesheets coming for staff and labour. What clients are actually being charged. What's on those timesheets? Are they incomplete? Are they at variance with, for example, most of the projects involving NEC that I've been involved in and I've been advising on, what you've got is some sort of electronic system where everybody who comes through the barriers is logged digitally, etc., whether it's fingerprints or a card with names, etc. Does that vary to the actual hard copy timesheets? I've had situations where you've got a variance between the two and it's over £500,000 between what's been recorded on the actual systems for those who are allegedly on site compared to what actually the timesheets that have been produced in substantiation have actually shown. And again, coming back to that, it's just reconciling that situation. Now, I'm not a criminal lawyer. I deal with construction and engineering contracts. That's 100% my bag. But allegations, for example, in that instance I've just mentioned, were being made of fraud. And who is the actual person on security administering those records, etc.? And how was the subcontractor able to obtain certain records which ordinarily from a GDPR point of view, they shouldn't have had access to, because only certain organisations, the employer, etc., should have had access to those records. Failure to off-hire plant and equipment in a timely manner. Otherwise, the project manager may take the view that that shouldn't be reimbursed, etc. Could we have a situation whereby the project manager's saying off-hire the plant, etc. Otherwise, it will be disallowed costs, which may not suit the contractor in terms of the sequence of work and in terms of how the programme of works have been organised, etc. This is an important one, which really should not have been paid to the subcontractor or supplier unless it's in accordance with the contract. Now, if we look at this in itself can be quite problematic. I've had situations where I've had to advise on this, where the contractor's put forward, and in fact, there's a few people here in the audience today who I've actually dealt with in relation to this particular issue here, where names are put forward and the employer's team disagree with who the contractor's chosen, or the level of documentation that's put forward is deemed insufficient, etc. Or the employer suggests that perhaps the pricing documents, there's more to it than what's actually been put forward. So they'd like to actually, I'm not going to say interview, I'd probably say cross-examine the subcontractor and to see if there's any underlying hidden costs or otherwise, which, with greatest respect, is well beyond what the NEC is proposing, is not to pull in directors of subcontractors into a room and interrogate them in that respect. Cost incurred only because the contractor didn't follow an acceptance or procurement procedure in the scope. Well, this is very important because significant most NEC projects all involve significant sums of money, and obtaining best value is in the interest of the contractor as well as the client. The assessment of that, if it's deemed that you haven't followed an accepted procedure, I think the difficulty comes in, how is that to be assessed? What is that extra over cost that's been incurred that which would not have been incurred? Again, incurred only because the contractor did not follow an acceptance or procedure in the scope. Well, something I've suggested to contractors who I've advised is try and agree something with the project manager, exactly what's going to be required by way of substantiation or otherwise at the start of the project. Let's not wait until we get towards the end of a project where I had one project, it was about £10 million in disallowed costs. That's not the time to have the debate about what's acceptable, what's reasonable, what's not reasonable. Try and have that conversation up front, right at the outset, rather than wait until we're in a position of disagreement, and the figures are significant. Sorry, I'll just get some water. In relation to scope, the point I've made there in the second bullet point concerns the extent to which, if acceptance involves the quality of work that's been carried out to reflect the scope. Now, we've got clause 40.1, which again would deal with the quality management system. So if the contractors, in terms of adhering to the contract and ensuring compliance, subject to whatever system they've got in place, that in itself would reduce level of disagreement, and that subject to the systems that are in place. This is an interesting one. Was incurred only because the contractor did not give an early warning, which is required, which the contract required it to give. And the key words being required, which I've put in bold and underlined. In this respect, I mean, yes, is to encourage the contractor to give an early warning, and in the absence of which, such costs may be disallowed. But the key words being required. And also, I come back to it, what costs could have been saved in terms of calculating and assessing what that disallowed cost would be. It seems easy, it sounds easy and straightforward, but it isn't, to be honest. And again, where I've been asked to advise, it's those sort of grey areas where the amount being deducted is absolutely significant because the contractor hasn't followed or given an early warning, the proper procedure which they should have done. Dealing with dispute resolution and disputes, this is an interesting one. To give notification to the project manager of the preparation for and conduct of adjudication between the contractor, a subbie or a supplier. Well, I think this is a key provision. I think enables the PM and or the client to get involved in trying to resolve where they can any disputes between the contractor, subcontractor or supplier. The last thing the PM or the client wants is to find that costs are being incurred, which the contractor's looking to be reimbursed for, which will then find out it will be disallowed costs, when really with the input of the PM or otherwise, perhaps a more reasonable agreement may be reached, which doesn't involve characters, egos or otherwise. I've had situations where something can be resolved. Sadly, I've said, look, this doesn't really need a barrister. It doesn't need a claims consultant. Sit around the table. And the comment's been, well, he insulted me last week on the phone. We had a Teams meeting in front of everyone and no, we wish to take this all the way and I want my day in court. Well, with the greatest respect, as I've said, I don't need your money. I don't think it's the right course of action. Get someone else to deal with it. It's the wrong attitude and the wrong approach. And the contract doesn't support that. So I think that is a good provision to have. And if the PM's input or the client's input assists and helps resolve matters before it gets too far, I think that's a good thing. Cost incurred, correcting defects after completion, disallowed costs incurred prior to, obviously can be reimbursed, which I'm sure we're all probably well aware in the crowd. Now, key point here is defects not complying with the constraint on how the works are provided as stated in the scope. So really, the key point to note here is whatever that constraint is, which could involve materials, methodology, or otherwise. Now, the cost of resources, and this is an interesting one, not used to provide the works. And the key part for me where I've been asked to advise is after allowing for reasonable availability and utilisation. Well, how is that assessed? What's reasonable utilisation and availability? And that's an area of considerable disagreement between the parties. And I've just given an example. I've said the PMs request that resources are stood down at particular times. Should that be disallowed cost or not? I come back to the point in the third bullet point that where possible, try and agree such contentious items with the PM at the outset of the project, rather than leaving that till the end when we've got a significant pot of disallowed costs. Preparation for and conduct of an adjudication or payments to members of the dispute board. Now, this head of disallowed costs is understandable because no client would wish to pay for the cost of legal proceedings being taken against them, as the parties, in accordance with the dispute resolution service contract, are required to pay in equal shares the dispute resolver. Also, and I think the last bullet point, something I've been involved in advising on, at what point does the work being carried out by a contractor amount to preparation for adjudication? Very contentious subject. If we're working on compensation events, etc., is it being prepared for the PM, depending on the relationship between the parties throughout the project, or is it now being prepared for adjudication level? I'd say there's perhaps could be a different standard. If it's going to adjudication, a lot more is involved than would be if you were preparing a compensation event to present to the PM for acceptance. Whereas if you're preparing for adjudication, for example, in terms of any programming, delays, etc., various methods of delay analysis, the type that may be adopted, whether impact as planned or time slice analysis, significant difference in costs. One could be 10, 20%, the other's 50, 70, 80% more, depending what you're preparing for. So I think that area in itself's quite significant, and it's something which, can be quite contentious. In terms of the case law, a case which most are probably very familiar with, the case of Bechtel. I call it Bechtel, it says Costain and Bechtel, where similar NEC type project, it was argued that the PM had abandoned impartiality in the cost assessments. The duties of the PM, looked at the duties of the PM when certifying payments. There's significant case law, generally not necessarily NEC, but to do with impartiality and certification duties, etc., of PMs and those in that sort of role. In this instance, chap from Bechtel allegedly had instructed staff to prioritise Bechtel's financial interests and to aggressively disallow the contractor's costs. It was claimed that there was an implied duty of impartiality, and the recital L of the contract, the spirit of mutual trust and cooperation. Key point, did they have a duty to act impartially, or at that time, in that particular contract, as opposed to NEC4, it wasn't the client, it's the employer's interests. It was argued certifiers, and going back to Sutcliffe back in 1974, must be impartial. That was what was argued. Bechtel argued otherwise. Procedural detail, employees facing role removes impartiality duties. it was decided by the court that the PM retains the discretion requiring judgment in NEC contracts. However, principles in Sutcliffe apply where that discretion exists. And the court overall rejected Bechtel's arguments in relation to impartiality and made it quite clear that it was unworkable. I think what was interesting in the judgment, and these extracts are actually directly from the judgment, is it would be most unusual basis for any building contract to postulate that every doubt shall be resolved in favour of the employer and every discretion shall be exercised against the contractor. Sadly, a lot of the disputes I deal with, even now, I've got quite a few cases I'm dealing with where exactly we've got the same situation. So sadly, that case law, which is still good law, is not being taken on board by PMs or others who are actually in that role of PM and making certifying, etc. At paragraph 53 of the judgment, it makes it quite clear. It's at the very least properly arguable that when assessing sums, there is a duty to act impartially, albeit you may work for the employer, but to act impartially between the employer and the contractor. PMs should understand their due role, and certainly when it comes to certification, avoid acting solely in the employer's interests when certifying. They still owe a duty of impartiality in certification, and it applies to NEC, but it applies to other construction contracts, and sadly, I repeat, I've got 3 or 4 cases on my desk at the moment involving certification, and where those in that capacity, PMs or otherwise, are not acting impartially. To summarise, disallowed costs represent a significant risk to contractors. What's required is robust systems in place. Accurate recording has been mentioned throughout the day. Records. It's absolutely fundamental in terms of challenging disallowed costs to ensure that you've got robust records in place. There's various software and others who have been here today speaking about what systems could be put in place and should be put in place. There's also an opportunity, as I've said in the second bullet point, from the outset to agree various elements which make up the fee percentage and the schedule of cost components to avoid these grey areas and arguments which are being had throughout the project or near the end of the project. Also, I think final bullet point, very relevant, is discussions on how the disallowed cost provisions will be applied in practice during the various stages, and not to leave it till the end or the life cycle of the project. The other thing I'm also finding, and I've known in a few of the cases I've dealt with in the last few months, is where a PM has been replaced by the client. So various conversations, discussions, agreements that have been made, albeit not necessarily put in writing yet, formally. PM gets replaced. You're now having a conversation with someone who's new, who's taken that role, and his view is, well, I've got to get myself up to speed with everything. I don't accept what's being said. XYZ has been moved to Singapore or elsewhere. He's not involved with this project now, etc., which is unhelpful. Thank you very much for listening. I think that's 2 minutes, is it? Yeah, quite a lot of material there, so I've just canted through quite quickly.
Okay, thank you, Charles. It's really good, isn't it, to spend half an hour analysing a single clause. That's not because NEC is complicated, it's an important clause. There's a lot of content to it. I just want to pick up on something Charles said right at the beginning, just to emphasise his point. I think he said this, and I'm going to emphasize it. If you're under an option C or an option E contract, I would generally say that's your probably biggest risk as a contractor, disallowed costs. Quick show of hands. Raise your hand if anyone's had a client introduce a Z clause that deletes some of the disallowed cost provisions. Seriously? Deletes? Okay, I'm slightly surprised. There was a few hands, and then a few retracted thing. Raise your hand if you've had clients introduce Z clauses that increase the number of disallowed costs. Okay, welcome to construction. So one plea I always say on training, and people say, yeah, that's a great idea, and they just don't do it. If you're a commercial, especially as we've got extra disallowed costs have been added in, please take the time to write a 1 or 2 page bulletin on your disallowed costs, blow it up to about A2, A1 size, make sure it's all around your office so everyone in your project team knows what constitutes a disallowed cost. Because who's gonna create most of this cost? The operational people, not deliberately, but because they will not know necessarily, especially with the Z clause ones, what would constitute a disallowed cost. Let everyone on your team know what would be a disallowed cost so they can then obviously try and avoid that from happening. So it's a recommendation. But hey, what do I know?